It's Nolan. Yeah, lot of controversy that do not disturb me. Got dreams of a million, cannot defer me. Got a ring on my finger, I retired my jersey. Fuck, nigga, y'all suck like the plot of Kirby. I'm him. All black on the scene, doing me high. No, I got the game covered like knee highs. I be killing all my foes like FIFA. Flows on kit like FIFA. Feel like EIO. Green on me like G.I. Joe. Hold my chest like a peacock glow. Southside nigga with an east side hoe. Hitting at the chicken number 3 combo. Type of nigga lead EB John Doe. 3D Camp Creek on the creek zone 4. With a nigga play street. Living cheeks on the floor. Can't speak no more. First verse in surgery, it's only me versus me. Nobody else hurting me. I burn niggas to the 3rd degree. Like Jazz O, niggas certainly. The best nigga that rap, I don't mean just virtually. These are the 4 Joe worker bees. I flex up like Hercules. I hit a nigga in the shit so hard that it hurt to sneeze. It's Nolan. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everyone is doing well out there. Of course, for those of y'all that don't know, Megan Thee Stallion, of course, y'all know. Megan Thee Stallion just dropped her Rocksteady music video featuring Flo Milli. If you would like to see my real-time reaction to that video dropping, you'll have to join on Patreon. It's patreon.com/RealJNolan, okay? It's going to be down in the pinned comment. I appreciate those of y'all that have already signed up and joined the Patreon. I greatly appreciate it. Had no idea that y'all was going to come through there and do y'all thing, do y'all stuff. But I greatly appreciate it, okay? So if you want to see that, you can tune in there. In this video, we're going to be addressing Miss Milagro Grrrls and Megan Thee Stallion and their ongoing court dispute. Now, just a few days ago, we were talking about the fact that they have a trial date set, right? But now, Miss Milagro has filed a motion basically seeking dismissal from the judge. She wants this case to be thrown out. We're going to go through her filing and try to see what her basis is for this case to be thrown out. I don't think it will be, but that's what they are currently seeking on Milagro's side. So let me go ahead and share my screen. Y'all know how we do over here. Let's talk, y'all. Let's get to the shits. All right. United States District Court, Southern District of Florida, Megan P. Plaintiff versus Milagro Elizabeth Cooper. Defendant's motion to dismiss complaint. Defendant Milagro Elizabeth Cooper through undersigned counsel pursuant to Rule 12b-6 Federal Civil P files. Her motion to dismiss plaintiff's complaint and in support thereof states the following. So this is her appealing to the judge for this to be thrown out. Introduction. As noted recently by law professor and author Jonathan Turley, we are living in an age of rage. It permeates every aspect of our society and politics. I find it very interesting that Milagro is leading with an age of rage when one would believe that all of your posts about Megan Thee Stallion and others as well online are pretty much based in rage and or rage baiting online for them to dump on her. So I find it interesting that you're leading with this, but let me continue. She says, this is especially true on the internet and online forums, which have become the new public square, which is why people even know who you are, because you shit on people for a living. This rage is especially commonplace in today's online universe where one can find inter alia a panoply of opinions, ideas, and rhetorical hyperbole, especially when it comes to celebrities. The recent trend by those who may dislike certain ideas or views expressed online is simply to silence or censor those views by arbitrarily labeling such speech as harmful. As noted by Professor Turley, notwithstanding any free speech rights one may have under the First Amendment once declared as harmful, it is no longer free speech and is worthy of censorship or cancellation. It is that easy. Just want to put a pin in this for a moment. The First Amendment right of free speech does not mean that you are free of consequence. It does not mean that you are free of, reaping what you sow. It does not mean that you are free of being sued, because that's the whole point of things like defamation, harassment, and other things of that nature They also exist because free speech is not because you can't say it. It just means that you have the ability to say whatever you want. However, there may be some sort of um, consequence on the back end of that based on what it is that you say. And that's not censorship or cancellation. But of course, people that aren't all that educated say things like this. And I normally don't attack people for their education or lack thereof, but I just find this funny. One such tactic, especially by those with the financial means, is to use the courts as a tool for intimidating and silencing criticism through expensive, baseless legal proceedings. This is precisely what is occurring in the instant case. The plaintiff is a well-known Grammy Award-winning rapper-entertainer with millions of fans worldwide who goes by the moniker Megan Thee Stallion. The defendant is a social media blogger with approximately 27,000 followers who has written about current topics including celebrities, rappers, and the entertainment world. Rather than rebut the allegations online, plaintiff chose to use the courts to intimidate and silence the defendant from exercising her First Amendment rights to publish her opinions and beliefs and also, to serve as a warning to other critics that if the plaintiff does not like what you say about her, you will likely have to deal with a federal lawsuit. It is not somebody's responsibility to rebut what you say. A person does not have to deem you important enough to rebut. But I shall continue. Oh boy. This is evidenced by plaintiff's complaint, which reads more like a press release than a legal document. Defendant submits that plaintiff's complaint, which is buttressed on dubious legal claims and irrelevant and impertinent allegations that at best only tangentially relate to the plaintiff, fails to state a cause of action under Florida law and should be dismissed. They say it in all caps. Background. Plaintiff's complaint purports to set 4 causes of actions under Florida law: promotion of an altered sexual depiction, Section 836.13, Florida statute; cyberstalking, injunctive relief, Section 7840485, Florida statutes; 3, intentional infliction of emotional distress and invasion of privacy, false light. Jurisdiction in the instant action is based on diversity through counts 1 and 2 and appear to be brought pursuant to the court's supplemental jurisdiction under 28 U.S. Code 1367. The gravamen of plaintiff's complaint is buttressed entirely on online posts either made directly by the defendant, reposts of third-party posts by the defendant, and by defendant pressing the like button on third-party posts. These posts can be divided into the following category. 1. Posts relating to the public criminal trial of Daystar Peterson, also known as Tory Lanez. 2. A repost of a third-party video where a talk show host offers opinions on whether plaintiff still has a drinking problem. 3. Name calling. 4. Defendant liking the post by a third party, Bimbella, of what is alleged to be a deepfake video of the plaintiff, followed by a June 8th, 2024 posting on X where defendant wrote, "Go to my likes." And 5. A June 9th, 2024 YouTube post by defendant where she raised the rhetorical question if plaintiff was a professional victim. With respect to the first category, plaintiff alleges that defendant posted online a false claim that the firearm Mr. Peterson used to shoot Miss Pete was not produced during the trial because it was missing. B. Can you even prove that you were shot? C. An LAPD report from Mr. Peterson's arrest stating that the first doctor to see Miss Pete confirmed laceration due to stepping on glass, not a firearm wound. D. Falsehoods and misinformation about the trial and witnesses while live streaming the trial that she attended and attacking the credibility of witnesses. On X, Milagro, stop talking about the case. We've moved on. Every time they lie, I'ma make y'all cry. A petition to free Mr. Peterson from prison citing exculpatory evidence, and that defendant, who with other bloggers were posting about the trial, said the following to NBC News: "On my end, everything is not going to be something that was intended to be a factual statement. It might have a comedic effect." I'm just going to keep going. With respect to the second category, plaintiff alleges that on September 2nd, 2024, defendant reposted a third-party video in which an unnamed talk show host stated, Megan allegedly still has a severe drinking problem from what I heard. I think she needs to spend more time in a relationship with herself and her therapist and maybe AA. That is a direct reference to Jason Lee, in which she reposted. With respect to the third category, plaintiff alleges that in August of 2024, defendant posted on X that plaintiff was caught trying to deceive the courts again when describing a lawsuit filed against plaintiff by her videographer. On July 30th, 2024, defendant posted a video where she said, what is Megan's mental status? Does she have a guardian or not? Has she been listed as a capable person? Has she ever been deemed like legally ARD? That's actually pretty disgusting, especially when we have no evidence that would point to Megan not being a capable person, as she says. But we'll keep going. Anything of the sort. December 24th, 2024. Huh? You mean 2023? Because we ain't even made it to December 24th, 2024 yet. Anyway, defendant posted on X stating, Megan wants to know what she has to do to stop being posted on certain outlets, and they say she's going to Cardi B, y'all hoes. My suggestion would be to just get over it or go away. Cardi won her case because Tasha K handed it to her. Handed it to her? You sure about that? Because hindsight may be telling us the same thing with you. Excuse my stumble. Other than that, you're going to get posted. D, that on June 22nd, 2023, a third-party X user, Holiday K, shared audio of the defendant calling plaintiff a lying ass hoe and claiming that plaintiff ruined Tory Lanez Daystar Peterson life and that the post was liked by defendant. And E, that during a live stream on Instagram Live, defendant in describing plaintiff's trial testimony called plaintiff an angry black woman and that she had an attitude. With respect to the fourth category, plaintiff alleges that in June 2024, an unknown third party by the name of Bimbella posted on X what purported to be a deep fake pornographic video of the plaintiff which had been circulating on X, and that the defendant allegedly pressed the like button on this post and later posted on X the comment, go to my likes. With respect to the fifth and final category, plaintiff alleges that following an article in a news publication, Up Rocks, entitled Megan Thee Stallion slams fake ass seemingly AI generated S tape circulating online, which mentions and links to the video as well as mentioning that the defendant liked the video on June 9th, 2024. Defendant later published a YouTube video where she discussed the Up Rocks article and questioned whether the plaintiff, a worldwide celebrity with millions of fans, was a professional victim. I don't see any of this being like super compelling, but I'm not a judge. I'm not a lawyer. Y'all can, register this how y'all see it. Accepting all of the plaintiff's allegations as true for purposes of this motion to dismiss, it is evidently clear that the plaintiff has not and cannot state a plausible claim under Florida law requiring the complaint to be dismissed. Defendant submits the following memorandum of law in support of the instant motion. Standard of review. Rule 8A of the Federal Rules of Civil Procedure requires a short and plain statement of the claim that will give the defendant fair notice of what the plaintiff's claim is and the ground on which it rests. The Supreme Court has held that to survive a motion to dismiss a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. And then they give a reference to another case. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Thus, only a complaint that states a plausible claim for relief survives a motion to dismiss. Demands more than an unadorned, the defendant unlawfully harmed me accusation. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Thus, a pleading that offers mere labels and conclusions or a formulaic recitation of the elements of a cause of action will not survive dismissal. Okay? So She says count 1 fails to state a claim for violation of section 83613 Florida statute. Okay. In addition to specific criminal penalties, this section provides a civil remedy of injunctive relief, actual monetary damages, or $10,000, whichever is greater, and attorney fees and costs against a person who willfully and maliciously promotes any altered depiction of an identifiable person without the consent of the identifiable person, and who knows or reasonably should have known that such visual depiction was an altered sexual depiction. Section 83613 was enacted by the Florida legislature in 2022. Currently, there are no cases interpreting the provisions of this statute. However, applying the general rule of statutory construction, it is axiomatic that statutes imposing a penalty must always be construed strictly in favor of the one against whom the penalty is imposed and are never to be extended by construction. Okay. To state a cause of action pursuant to this statute, the plaintiff must establish the following. 1, that the defendant willfully and maliciously promoted an altered sexual depiction of an identifiable person. That's not going to be hard to prove. 2, without the consent of the identifiable person depicted, easy to prove. And 3, that at the time the defendant knew or reasonably should have known the depiction was an altered sexual depiction. Also, I don't see how any of this that you're putting down is going to help your case. All of this is very easy. It ain't like Megan went and looked for it. People put it on her radar that, hey, this is some deep fake of you. So it didn't take no genius to recognize what was being spread. And clearly it was against her consent because she never consented to that being produced. Under the statute, promote is defined as follows. Promote means to issue, sell, give, provide, lend, mail, deliver, transfer, transmit, transmute, publish, distribute, circulate, disseminate. Disseminate might get your ass. Circulate might get your ass. Present might get your ass. Exhibit might get your ass. Send, post, share, or advertise, or to offer, or agree to do the same. Given that this court must strictly construe this statute, it is evidently clear that the plaintiff's complaint is suggesting that this court do the opposite by promoting an overtly broad definition of what the term promote means under the statute. This is not compelling. In her complaint, plaintiff alleges that in June 2004, some unknown person created a deepfake video which depicted a realistic version of plaintiff with computer-generated nude body parts presented as the nude body parts of plaintiff engaged in conduct which plaintiff did not engage or participate. So you're talking about June of 2024. Megan alleges that an unknown person created a deepfake about her. Got you. We already knew that. The complaint further alleges that we know you did that. That's not an allegation. That is the truth of what you did. It's available. Interestingly enough, the complaint also alleges that the above allegations were reported on a news publication, Uprocks, which also itself linked to the same video. The complaint then alleges the defendant she's utilizing. Oh, boy, you and your attorney seem to be in over your head. Yes. She's referring to the article which shares the same video because she's letting it be known that your actions were covered by press, which further embarrassed her in a public way. Y'all ain't too bright over there. The complaint then alleges that defendant then published a video entitled Milagro Grams officially responds to blank 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 on YouTube, where she addressed her ex-post related to the deepfake video, where in the YouTube post she questioned whether Miss Pete is a professional victim. To suggest that these allegations fall within the scope of the statute is a serious overreach. We'll let the judge determine that. It is undisputed from the complaint's allegations and the cited links to the online publications that the defendant did not create the video, nor did she repost or share the video on her social media or any other media. There are no allegations that the defendant represented whether or not the video was authentic or not, All that is alleged in this lawsuit is that 1, the defendant liked the video, which had been posted in an online public forum. Defendant later posted a tweet saying, "Go to my likes." And 3, defendant later published a YouTube video where she discussed the Uproxx article and questioned whether the plaintiff, a worldwide celebrity with millions of fans, was a professional victim. In fact, the conduct defendant is accused of engaging in is not so different from what the media site Uproxx did by linking to the purported video. Notwithstanding that, 836.13 is a statute with criminal and civil penalties where its definition of promote must be strictly construed. Plaintiff is suggesting here that merely liking, linking to, or talking about an online post regarding a public figure is a criminal offense, subjecting one to criminal and civil liability. This argument is perverse and frivolous given the clear statutory definition of promote. The statutory definition requires that the violating party actually put the offending video into circulation, or that they provide a copy of the offending video to someone, or that they post it or provide a copy to the video in exchange for remuneration. Plaintiff's distorted interpretation of the statute would clearly be unconstitutionally overbroad. In fact, if plaintiff's view had any merit, then any news organization such as Uproxx, which linked to the video and spoke about the video, or any individual simply pressing the like button will be subjected to criminal and civil penalties. There is no factual allegation that the defendant procured, manufactured, issued, or sold the video. Neither is there any allegation that defendant provided a copy of the video to anyone. The complaint is devoid of any factual allegations showing that the defendant broadcast or transmitted the video or transmuted it, blah, blah, blah. Nor is there whatever. There are no factual allegations that defendant shared or disseminated the video. Okay. So she's trying to absolve herself of any wrongdoing, basically, and she wants the judge to throw it out. I mean, simply stated. Count 2 fails to state a claim for cyberstalking. It should be filed in the domestic division of the circuit court. So here, she's saying that she did no such thing as cyberstalking. Count 2 of the complaint purports to bring a claim for injunctive relief pursuant to Section 7840485, Florida Statutes cyberstalking provisions. As this claim does not provide for an award of damages and seeks only injunctive relief, presumably the plaintiff is attempting to bring this claim by invoking this court's supplemental jurisdiction pursuant to 28 U.S.C. 1367. Again, while it is difficult to discern what the facts the plaintiff is specifically relying on to support a claim of cyberstalking, Count 2 should nevertheless be dismissed for plaintiff's failure to follow the mandatory statutory requirements set forth in 7840485. Specifically, it states that a person who is a victim of stalking has standing in the circuit court to file a sworn petition for an injunction for protection against stalking. Further, it requires that the petition be filed under oath and follow the format outlined within the statute, which plaintiff fails to do so here. As Count 2 is not under oath and fails to comply with the statutory requirements outlined in Section 3A, it should be dismissed. In the event that the plaintiff seeks leave to amend on Count 2, the court should deny this request and decline supplemental jurisdiction over the claim. Let me see here. What else is here? Judge. There's something else. Further, the court stated in dicta its doubts that the Florida legislature intended that claims under 7840845 would be litigated in federal court because the injunction contemplated by the statute is akin to a DV injunction that state court judges who regularly preside over injunction dockets are better suited to handle on the expedited timeframes in the statute. In a subsequent decision on the same case, Judge Weatherall noted that while a federal court could theoretically exercise supplemental jurisdiction over a 7840485 claim under 28 U.S.C., however, upon further reflection, he found that there appeared to be compelling reasons for declining jurisdiction. In reviewing whether supplemental jurisdiction should be exercised, the judge on an example case considered the host of factors of judicial economy, convenience, fairness, and comity. In doing so, The court held that the factors appeared to weigh against exercising supplemental jurisdiction. The court noted that judicial economy is served when issues of state law are resolved by state courts. This is particularly true where, as here, the claim is based on a state statute that requires expedited procedures that are better suited for state court judges who, unlike federal court judges, regularly preside over statutory injunction dockets. So she's saying that they sent the cyberstalking case to the wrong court. Rather than go to federal, it should be a state level. Okay. Count 3 fails to state a claim for intentional infliction of emotional distress. Count 3 purports to state a claim for intentional infliction of emotional distress under Florida law. A plaintiff must plead the following elements in order to state a claim for intentional infliction of emotional distress. 1. Extreme and outrageous conduct. 2. An intent to cause or reckless disregard to the probability of causing emotional distress. 3. Severe emotional distress suffered by the plaintiff. And 4, that the conduct complained of caused the plaintiff severe emotional distress. Thing about emotional distress, it's very tough to object because we don't know what can emotionally distress somebody. So I don't know. We're going to see. I'm going to skip past these examples. Whether conduct is outrageous enough to support a claim of intentional infliction of emotional distress is a question of law for the court to decide, not a question of fact. Again, it is unclear from plaintiff's shotgun pleading as to what particular allegations form the genesis of this claim, whether it consists of the allegation that the defendant pressed the like button on an unknown third party's social media post purporting to depict a deepfake video, or defendant's online comments on her blog about a California criminal trial involving Mr. Peterson. You saying involving Mr. Peterson as if it also didn't involve Miss Pete. Or defendant's online post encouraging her followers to sign a petition to free Mr. Peterson. Or defendant's posting of a talk show video where the television host stated that plaintiff allegedly still had a drinking problem, or her posting of a police report or calling the plaintiff an angry black woman, or if it consists of all the above. Assuming, arguendo, that all of the complaint's allegations are being relied upon to support count 3, the allegations still fail to reach the difficult but necessary threshold under Florida law sufficient to state a claim for intentional infliction of emotional distress. Even if true, plaintiff's allegations pale in comparison to the plethora of court decisions that found significantly more egregious facts to be insufficient as a matter of law to meet the requisite outrageousness needed to state a claim for intentional infliction of emotional distress. In the limited number of cases where outrageous conduct was found, the facts were quite severe, usually involving SA. For example, another example. In contrast, the following cases, which are significantly more severe than the plaintiff's allegations in the instant case, the courts found that the conduct was not so outrageous in character and extreme in degree as to go beyond the bounds of decency and be deemed utterly intolerable in a civilized society as required to state a claim for intentional infliction of emotional distress under Florida law. For example, the 11th Circuit and blah, blah. More examples, right? Dun, dun, dun. As plaintiff's allegations are clearly not so outrageous in character and extreme in degree as to go beyond the bounds of decency and be deemed utterly intolerable in a civilized society when compared to the body of case law, Florida, count 3 of plaintiff's complaint for intentional infliction of emotional distress should be dismissed with prejudice. And we got count 4, which is the complaint of invasion of privacy, false light. She also believes should be dismissed. So she believes all 4 counts in Megan's lawsuit should be dismissed by the court. Okay. At this point, I'm a bit exhausted, so I'm not going to go through that last count. But I appreciate y'all for tuning in and rocking with your boy. I don't know how strong this motion for dismissal is. I think it's not going to get tossed out. I think Milagro is going to have to stand trial. She's going to have to go to court and fight this thing. Megan's going to have to come in and produce, her evidence of her claims. And they're going to have to work this thing out. I don't really see where Milagro has a dub or win in sight. But again, I am not a judge. I am not a legal professional. All I can do is read what's available, give my own interpretation based on information and belief. And we're just going to have to see how this thing pans out, because it could go either way. But I think Megan has a compelling enough case that can show that Milagro has been harassing her, because that's exactly what she's been doing. She knows that's what she's been doing, and she's trying to find a legal loophole that would allow her to continue to do so without consequence. That's all this is. And I'm hoping that the judge sees through it, because it's one thing to talk about celebrities. It's one thing to talk about current events in the world. It's another thing to just completely dump on people with no sort of regard for that person. That's why even in instances where I talk about Drake on my channel, I show a certain level of restraint. Some people may interpret that as fear or not wanting to go against, or, be perceived in a certain way. But honestly, in these internet streets, uploading these videos, you got to be careful what it is that you say, because anybody communicating on a public platform with thousands of people tuning in, you are now at risk of having this shit all taken away from you by saying the wrong thing, right? Just had somebody that was like, by definition, Aubrey is a PDF. And this is why y'all should stay in school. I'm like, damn. So you dumping on me because I said I wasn't willing to say that on camera, that, you know what I'm saying? I'm not, damn, okay. I should have stayed in school? Bet. But ain't nobody gonna pay a nigga legal fees if I get hit with a defamation suit. It's gonna be all on me, right? This is the way it goes. It's the landscape we live in. You gotta be careful with what you say. And you gotta be able to communicate your beliefs in a way that's in respect to the subject of whom you're talking about. Otherwise, you put yourself at risk, okay? Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. Again, if you want to see my music video reaction to Rocksteady featuring Megan Thee Stallion and Flo Milli, you can join the Patreon, become part of the club, and I'll see y'all on the next one, all right? Much love and respect, y'all. Peace.
King of my city and cul-de-sac. Coming out swinging like soldier rag. Leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind. Knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive. I need my check. Spinning the block for the Gouda. We hitting the jeweler to flood out the net. We don't do beef for computers, I'm straight out the sewer. We come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. But drama, I'm fully abreast. I was ready for years and they died of me. All of a sudden they tell me they proud of me. I been dropping these haters like calories. Cross them out, I came back with some boundaries. Stand for my honor, but you run no corner. Packing the stick with a drummer. Wanna catch my bad, won't fumble. I done came too far to be humble.